The regulation that alters or impairs or enlarges the scope of a statute is null and void. And so the question I have is, to the extent these proposed regulations deal with physician availability, they would be consistent with the statute, which, if I recollect my administrative law, is that the test for a valid regulation is it has to be consistent with the statute and reasonably necessary to effectuate the purpose of the law. And so to the extent talks about concepts regarding, I think you could go to a physician being competent, because that's kind of availability. You want to avail a physician that's, you don't want necessarily any physician. Hey buddy, walking down the street, this isn't a carjacking, I'm from the medical, I'm a healthcare professional, I need a physician. I think you want somebody trained in that, but enlarging the scope of the regulations is something I think we ought to be very mindful of. Do these four proposals, as the chair said, do they differentiate between licensed healthcare provider? No, they do not. They do not embrace the difference between an RN or a physician assistant. And with all full disclosure, I was PA's counsel for a while. I think most of you know that already. Do these four proposals address training? No, they do not. Do they address things like a backup plan and everything else? And of course, no, they don't do that. They don't do that either. Mostly because we, and as I was heavily involved with this writing of this memo, was trying to keep it consistent with the statute. Now, it may be the case that this committee is unable to come up or can't come up with a with a regulatory proposal, and perhaps which case it would be necessary to go back to the legislature and say maybe physician availability isn't the silver bullet we're all looking for. Maybe it's training, or maybe it's who, or maybe it's what, or whatever. So I just want to kind of try to draw a little box around there, that the reason these options are kind of flavored the way we are is that I was doing my best. I think staff was doing its best to honor.
Well, if I can, let me put my attorney hat on for a minute. My understanding, when we do draft regulations, you can do in the definition clause. When we do definitions, when you put physician, you could put the definition that this physician, to be adequately responsive, has to be somebody, and we can put it in that definition.
I would agree with that.
Okay.
Yes.
Well,
could we just say the supervising physician? Because that would, therefore, by definition, the supervising physician must be in that field, right? So you have...
Not necessarily. Nurse practitioners, nurses get asked to do this all the time, and they don't have... But the physician that's supervising them does not have to be adequately trained. There's no requirement. If we get ads all the time, come and do laser at this med spa in Laguna Niguel, and it doesn't mean that that physician has to be in that field or trained in that field. And
no, but that's what I'm saying. If we made the regulation that instead of a physician shall be immediately available, a supervising physician. Because
what I'm saying is, supervising physician by definition doesn't have to be adequately trained in what that person is supervising.
But I thought you were
no, that's
that in the definition.
They don't.
Wait, you can. I thought if you're under standardized procedures, whether you're NPPA or an RN, your supervising physician has to be trained in what you're doing.
Not necessarily. All they have to know is that you can do what you're being asked to do. In standardized procedures, there has to be a thing that shows back that you were adequately trained in it. And that's what's going on out there.
Well, I know what's going on, but I thought the nursing board rules.
No, the nursing board gave a presentation to this committee and specifically said they are independent providers, and a physician gives an order. They do not supervise. They do not do anything else. They give an order.
What I'm saying is, if we craft in the definition that the physician who has to be readily available has to be, and we could say appropriately trained in this particular technique that we're trying to regulate, that might be the way to catch it in there without being overly broad.
And the patient shall be notified as to who is the physician on call or whatever. Because I think if your name is attached to something, you're going to be way more careful about what happens to these patients.
Well, the way we might have to phrase that so we're not overly broad and have the legislature come back and say, this is what we ask, is we would have to say, as part of the availability, that somehow that has to be communicated to the patient, how the physician is available. You know, we can say they have to be available, and the means they have to be available, and that has to be communicated to the patient as well.
I have had no less than 20 people come to me to get problems fixed because they couldn't even find the physician. There's no on-call, there's no nothing.
Mr. Kepler, would that be appropriate if in...
I'm trying to create a diversion.
I know you were. I know you were. But if we do in the definitions and what we are trying, obviously, capture what the legislation has asked us to do about availability and supervision, and then make those definitions.
It would be a bit of, in all candor, it would be a bit of a stretch.
Well, let's stretch it.
Okay. Stretch Armstrong here. I do want to point out, we've talked about length about supervision in various incantations of today. I'm not seeing a whole lot of supervision in the statute. What I am seeing is a whole lot of availability. Right. And I want to make that key distinction. I don't think supervision, being PA counsel, I mean, let's be candid, as was stated before, there's sort of a tethering that goes on there. The PAs are sort of tethered to a supervising physician. The law prevents the medical board from telling the scope of practice of an RN, I rely on Ms. Shipsky. I don't think that supervision element is necessarily there, and so there's the standardized procedures a little bit different. So I kind of want to knock us off on one leg on the supervision issue and like to concentrate on availability. I think you could have a regulation that said, again, it would be difficult to do right now, but you could say, when we talked about a physician availability, you could talk about which physician you're talking about, and not a physician walking down the street, but a physician who's competent in whatever is happening, whatever the procedure is, because logically you would say, if I'm going to call for backup, to use a Hawaii 5.0 or CSI metaphor, you'd want somebody backing you up who's confident in whatever is going awry. It seems logical to me.
And I would argue that by us stretching it, this satisfies the legislative intent. The whole purpose of this legislation was the concern about the lack of competency training and supervision, and so we can oblige them and stretch a little bit.
So my question to council would be, the wording I'm going to read to you stretch beyond the boundaries of acceptability or wherever we would get into trouble? And that would be taking it from about the middle of number 4. A physician with relevant training and expertise shall be immediately available to the provider. For the purposes of this section, immediately available means contactable by electronic or telephonic means without delay, interruptible, and able to furnish appropriate assistance and direction throughout the performance of the procedure and provide appropriate backup care plans, something like that. And the word appropriate, to me, is a way of getting into the ideas of what procedure is it, what provider is it as a PA or an RN or an NP or whatever, what's the location, where are emergency services, all of those things. If you're going to, if you say able to provide appropriate assistance, you have to include those kinds of things, but you don't have to write it into the language. Would that language pass muster?
The problem is, in all candor, it's not me you have to convince, it's the Office of Administrative Law. But my legal opinion, you'd be right on the edge, because you're essentially not right on the edge, but you're getting close. Yeah. I think you could give it that old college try if you get it. My fundamental concern is the more sort of appropriate and relevance we sort of add in to sort of soften that. In my opinion, and I'll defer to Ms. Dobbs here, maybe you start bumping against the clarity standard then is what does that actually mean? Right. And so I think it's sort of, we're sort of walking a tightrope a little bit, but Diane, would you?
I agree. I think your regulations need to be as clear as possible. And if you have something in there that then causes someone to say, well, what does that mean? What does appropriate mean? Then you're missing the mark on what really meets the clarity standard.
Unless we put it in the definitions area.
If you put in the definition, then that helps.
Right. Yes. And I want to address 2 points that have been brought up by people to make sure that this is inclusive. One is the issue of, because you remove the physical boundary, and that what the issue was, can you be out of state and telephonically available? And I don't know that that was ever the intent, but the way that this was crafted, you could be. Number 4, you could be out of state and telephonically available. So that's one issue that needs to be addressed. And the second issue, it sounded like we need to address, is that, and that the patient shall be informed of the availability of the supervising physician, or whatever, if you want to address it that way. So then that covers the patient being able to get the information of who to call if the physician isn't physically present at the site at which this procedure is being done.
Okay, I cannot go with the out-of-state thing. You would not deliver a baby and have your doctor be out of state. You would not do surgery and have your supervising or whoever physician be that far away.
Oh, no, that's why we brought that up, because the way this is written, it says without physical boundary, which means we have to out of state. Yes, Dr. Robbins.
There's another bill that has been recently...
Mic over.
I'm sorry. There's another bill that's been recently passed by the state legislature, which I'm not sure that it directly hits what we're talking about, but it certainly comes close. And that was a bill that was introduced by the derm surge people, and I think it's AB, somebody will help me on these numbers. 1548. Pardon me? 1548. It's AB 1548, and it was directed exactly at the corporate practice of medicine, and the lack of training of those people who were pushing into this field from corporations. And the interesting thing about that was that it passed with everybody's approval, and there was almost no conflict of interest in it. And I think we can take some of the wording from that law and use it in crafting our own.
We can read it back.
And I'm just recommending that we look at it.
If we could do this, if we could just go down the table, if you have one more comment, and then what I'd like to do is ask for the public comment now that they've heard our discussion. So, Dr. Kumar, if you have anything you want to add.
I have a question of legal counsel before we get into that, if you don't mind. I know, Mr. Kepler, we looked at other states that were dealing with some of these similar issues, and especially Medispas and the scope of practice and everything. And it was found out that the state of Iowa, the state of Oklahoma, and Florida have passed laws that have defined this, have drilled it down to where they wouldn't have this discussion in this room right now because the law has been passed, that you have to have a scope of practice within that entity that you're practicing. And in fact, in Florida, they say you have to be a dermatologist or a plastic surgeon to give these services. They've even drilled it down even further. So I don't think we have a prayer to include the word scope of practice into this. I think what Dr. Finney was saying, that a person who's backing up or the person who's doing the procedure should have a relevant training or whatever language that was used there. But using the word scope of practice kind of drills it down even further. But I don't think we have a prayer of doing that, or do we?
Scope of practice as it sits now, I think the reason that scope of practice is mentioned in this is because, as was pointed out, there's only the medical board. Let me back up. The medical board has authored a precedential decision saying you penetrate the skin. Penetrate the skin, that's the scope of, you're into medicine now. And so, an amount of clarity, what I was trying to suggest is I didn't want this to be appropriate, that you could let your licensed, I used to be counsel at bar, your licensed smog check technician perform laser because your supervising physician said it was okay. That's the reason what I was trying to avoid. So my rationale was, if in fact your scope of practice, whoever, because the law clearly contemplates that it's not a physician that's going to be doing the procedure. It's somebody other than a physician, because if a physician was doing, we probably would not be having this conversation. It's somebody else. So who's that somebody else? And whoever that somebody else is has to have that ability to do laser within their scope of practice. That was sort of my rationale. Crossing that threshold, and the next one was, okay, then you got to have a supervisor, you got to have a physician, not a supervisor, a physician around somewhere. How close, how far, the proximity, the connectivity, that's all the issues that are trying to be embraced here. Candidly, the way the number 4 is written, you could conceivably use hyperbole, have somebody on the moon, and as long as they were NASA or Houston, we have a problem. As long as they were readily available, they could conceivably do that. I use that for hyperbole only. So there are states that, Dr. Bruner, you're exactly right. There are states that have beaten us to the punch. There are, and I think we had one of our initial meetings, I think we talked about some of their approaches.
On that note, then, Dr. Bruner, what I'm wondering, could we be so politically bold as to send a message back to the legislature that we don't feel that this statute adequately protects the consumers in the way it needs to be crafted, and that what we do need from the legislature is a law similar to what you're indicating, that more spells out the requirements of those that provide it, in addition to who supervises, as well as the availability. I mean, we, quite honestly, politically, we always have, I think, have that option. If we're not comfortable that this adequately protects.
Within our, sorry for interrupting, but within our codes, maybe is there a midwife here? Perhaps you know where I'm going with this. In their code, it says the midwife will be supervised by someone who has some sort of OBGYN training.
Give me just a second, Dr. Jack. I'll pull the...
Thank you. But it says that very specifically, and I think it's a very relevant fact that a midwife, has to be supervised by...
The practice constitutes the furthering undertaking of any licensed midwife under the supervision of a licensed physician and surgeon who has current practice or training in obstetrics. So clearly it's not, while we do license plenarily, we do not, it's clearly this is not any physician. It's a physician.
Training.
I'm sorry?
It's cleared out. It is stating that it is required they have training in this area. They don't have to be certified, but they have to have training.
Practice or training in obstetrics.
Yeah.
You go down the table, and then let's listen to the public, and then we can come to some kind of recommendation. Dr. Himmelrich.
Yeah, good. So I just want to reiterate, I think we could say the physician, because we're talking about laser intense pulse light, physician trained in these devices, so you could say it that way. And I want to make sure we have some way to limit how far the feet can walk.
I think 4 is as close as I think it's article number 4 we're talking about. Is that right? Mm-hmm. Yeah, I like it. I think to define a distance to go it's going to be impossible because of what I said a while ago about the downtown LA different than the upper desert. So I would say it's probably a poor substitute, but the standard of practice of each community has some weight in these regs. So a standard of practice, I think, might prevail in something like this and help.
That actually is option number 1, is the community standard.
Okay.
Dr. Samuelson.
Well, I go with the hybrid. Choosing number 4, but not putting a time restriction on it, because I think if we pin down who that responsible physician is, their own fear of liability should keep them within the striking distance of the site.
And remove the physical boundaries?
I wouldn't define the physical boundary, personally.
Take that out, because if you say without...
readily available, but I wouldn't specifically say electronic. Readily available, period.
Changes everything. Well, we have telemedicine physicians that actually testified, and that would significantly change their relationship to be able to...
Yeah, well, I don't see a reason to be that specific. I would say readily available, because I think it's one thing to telemedicine to diagnose, do you think that's a melanoma, do you think it should come off? I think telemedicine, beautiful, great. But to respond to anaphylaxis, not that great. So that's why I wouldn't offer up the electronic option, but simply define it as readily available.
So a Twitter account wouldn't do it. Just never know.
It's obvious from my previous comments where I stand in this, but The ray of light that I have heard actually comes from you, and as it usually does, and that is to go back to the legislature and say that none of these, as they stand right now, offer the protection of the patient nor the professionals adequately, and that we would like to consider other matters, other issues that have been brought out in our discussion.
And perhaps we could define those issues once we finish, if we want to go in that direction, about supervision, training, competency, those kind of things.
Yes.
You know.
But I would hate to lose ground and not have something happen after all this. So couldn't we have this be there and then say what we need in addition is defining training supervision?
Personally, I don't think that you can talk about where they are until you know who they are.
Okay. Dr. Bishop.
I may be wrong. I might have misinterpreted the recent required meeting I went to, but does not the medical board have the ability to craft regulations in the absence of the legislature?
We have, Dr. Bishop, we have generalized rulemaking authority, but please understand that the purpose of regulations is to implement, interpret, or make specific statute.
I think we are. I think what I'm saying is I think we would be interpreting and implementing the gist of this statute. They may not have specifically said this, but they really meant that they want to protect the patient. So I think, although I can, as a fallback position, I can agree with 4, but I would like to say if we agree with 4, we should go forward with trying to craft something that really is based on the spirit of what they really wanted to do. And I think we should push the envelope here. And if it gets kicked back to us, it does. But I do think that this was a incomplete legislation, not by fault, but by perhaps ignorance. And I think that we can do better with what we've learned. Yeah.
Yeah, I agree. I like 4 with a further definition of what that position should be. The only other thing that we haven't discussed at this meeting is whether some kind of ratio is appropriate.
What's the supervision ratio?
Only because I think some of the concern is that medical doctor in name that has 20 nurses running laser
There is a law.
for RNs in an outpatient
I think
setting.
there is a law, how many nurses and how many nurse practitioners physicians can supervise. It's 4.
27, 25,
Yeah.
27. I think it's 4 at the moment.
For RN?
4 for an 4 to 1 for a supervising physician to a nurse
Nurse practitioners and PAs are 4 to 1, but I don't think it applies to RN.
I don't know about non-advanced practice RNs.
But there is for nurse practitioners,
Yes.
because they're not allowed
Right.
to sign more
Yes.
agreements than I think it's 4 or 6 actually.
It may help to limit the concern of that multiple centers using one physician and having the physician not truly available by putting some ratio in there. But I do also think that it would be appropriate to consider sponsoring legislation or co-sponsoring legislation that would define what the competency and certification is, just like, I mean, there's definitely precedence with the fluoro, there's definitely precedence with Accutane, Suboxone. I mean, there's things that you have to pass a certification before you're allowed to do that. So I think that wouldn't be a difficult legislation to pursue.
I would agree wanting to do that separately and concur with Drs. Kilmer and Simon that I think we ought to do this here and can do this here and maybe even if we have to stretch it a little bit. Ms. Chispy asked me to complete some language that I would suggest will fill out option number 4 in a way that I think our discussion implies to me at least we would be comfortable with, and starting again on line 4 of option 4 after the word license, it would continue a physician with relevant training and expertise shall be immediately available to the provider. Where am I here? For the purposes of this section, immediately available means contactable by electronic or telephonic means without delay, interruptible, and able to furnish appropriate assistance and direction throughout the performance of the procedure and inform the patient of provisions for post-procedure care, because I think that was something we were worried about. So I think if those pieces are in there, and I disagree about ratios. I think that's getting, because there's so many variables, I think you'd have a hard time defining which procedure, you'd have to get into which procedure and which, is it a PA or an RN, and I think it'd sort of be a rabbit hole. But I think with the language, something like this, it would cover enough bases and not get counsel too far out. If there are ambiguities in the language that we could address in the definitions, perhaps that would take away that, okay, what does that mean, issue that was brought up over here. But that would be my suggestion.
I think any of those qualifiers, such as appropriate, we could handle in the definition area as to what, we could try as to what constitutes appropriate, and any of the other qualifiers. What I'd like to be able to, and relevant training, what I'd like to be able to do, if I can, is call the public. They've heard our discussion, and then after we're done with the public, we'll bring it back behind the rail, and then we can make a motion of where we want to go with this. So the speaker, Yvonne Chong from CMA. Did I get that right? Mm-hmm. Okay.
The CMA.
Yvonne Chung with the California Medical Association. In listening to the discussion of this committee, I think we're largely in agreement with most of what's been said, and particularly with Dr. Finney's comments. I think those are good additions. A couple other things you might want to think about adding is after acting within the scope of his or her license, and something along the lines of in adherence to standardized or agreed upon procedures or protocols, because I think that addresses the PA issue, and that you have they have a scope, but your scope is dependent on your agreement. So I think, putting something that says that the provider and the physician have agreed upon, when they're going to contact and in what situation that conversation has been had. And in defining immediately available, along this issue of whether or not, you can have a physician who's out of state, possibly saying, or has designated an attending physician who could be physically present, or, just to show that they have covered themselves in that way. So that's another thing that you might want to add, but otherwise we're in agreement. Thank you.
Okay. And I think we can actually tweak this language, because usually, I know you would say that this shall be contained in standardized procedures and protocols, so that we're making the requirement, we're defining the appropriateness and the backup, and then saying that this shall be contained in their standardized protocols. That also would help actually RNs. There have been numerous cases where RNs have worked and done this and didn't know, the physician supervising didn't know they had to have standardized procedures. So this would be very helpful on that end too. Carl Powell, Dr. Carl Powell, California Academy of Cosmetic Surgery.
Good afternoon. I'm Dr. Carl Powell. I'm a general cosmetic and laser surgeon. I own 2 medical spas. I've dealt with this for about 9 years now. The first point that I would like to make, that a medical spa is a medical practice. It should fall under all regulations for any other medical practice. I think that is perfectly clear. There should be no differentiation. The second point, laser procedures with class 3 lasers are surgical procedures. Medical surgical procedures. What we do in medical spas are medical or surgical procedures. They penetrate the skin, they destroy tissue, or they alter tissue. So they need to be regulated just like any other medical practice. What you are dealing with here, I have this advertisement from a magazine in San Diego, a nurse who basically practices medicine without a license. It's a medical spa. Her medical director is in Orange County. He has graduated from medical school but done no residency, has no board certification, runs an acute care clinic, and spends most of his year traveling with professional surfers as their doctor. So he's not available at any time for this nurse who practices under his license. This is why this is a very important thing that needs to be addressed. It really boils down to medical director or whoever owns that practice supervision. That's really what it is. You have these medical directors that work for these major corporations. They get a paycheck every month. They never show up. They never do any training. They never do any chart reviews. Charts may not even be kept. They're not available for help with the procedures. They're not available for any problems that come up with the treatments. And they're not available for any injuries or emergencies that come up. So from my point of view, the medical director or the physician that owns that practice, and he has to own 51% of that practice, that is law. 51%, and a layperson cannot own that practice. That doctor needs to be has spent time on a monthly basis in that practice. That could be one day a week or one day every other week, but he needs to be there. He needs to see what's going on. He needs to supervise. He needs to provide training. He needs to do chart reviews. There needs to be peer review. There needs to be credentialing, which means training, which you all have been talking about. So I hope that this committee actually addresses that. I make myself available. If there is an injury, I can be there within 30 minutes. I think that's a good time limit. The doctor cannot be out of state. I know another practice where the doctor's in North Carolina for surgical procedures are being done, and the practice is being run by lay people. Sorry it took so much time.
No, thank you. Kathleen McCollum, Northern California Aesthetic Nurses Association.
Hi. As a nurse in this field, I really appreciate the direction you're headed today. The issue is, as you know, people operating these offices, medical offices that are not primarily physician-owned and not appropriately trained or supervised. Clearly, that's where the issue lies. I do want to say the standardized procedures is really important and often overlooked. When there's an emergency and there's anaphylaxis, I better know that I need to reach for that epinephrine and not be waiting 10 minutes to get a hold of my physician. I have to have those standardized procedures there now. And that is critically important for every single complication we have. The other thing is I love the talk about the on-call after hours. Most often with light-based devices, you see evidence of a problem hours later when the burn becomes evident. So it seems like that is a really good and appropriate direction, because a lot of times you can do an IPL or other treatments and there's really no evidence at that moment that it's too hot. The issue about the state line is kind of interesting. What if my practice is 10 minutes from the state line? It gets a little funny if you think about where people are located, and yet it does seem logical to be within the state, but really immediately accessible is more important in my opinion. We can always call 911 and that can be one of our protocols, but being an hour away may not be adequate at that time no matter what, even if you're in the same community behind a traffic accident. So again, it goes back to knowing your standardized procedures, responding to emergency, communicating with your physician, getting their oversight immediately. I think that, the only other thing I wanted to also suggest is, and it kind of came up, we are defined as to what procedures we can do by rules that are already in existence, the Class 3 classifications of these devices, although there's a few that are kind of fallen outside of those classifications right now. Thanks.
Thank you. Norman Davis.
Hello, I appreciate the chance of taking 3 minutes, and what would a committee meeting be without some comments from Norm Davis, right? I really appreciate the chance of being here, and I want to congratulate this group. If you synthesize what came out of this group today, it's more than has happened in 5 years. Your comments, Dr. Finney, are totally appropriate. Your comments about adding some time dimension of response, either by the supervising physician or his designated appointee, that's critical in this. Without it, you don't have any teeth. You've got to have something that relates it. You've got to define a supervisory physician. You have to define that by definition, or nothing happens. You have mush. Dr. Powell has indicated ever so well exactly what's going on in this field. It's a tragedy that these centers are being run by lay people who hire a doctor who lives in North Carolina and have some doctor that might take a phone call because he's getting a few $100. It's a sin. And there's no accountability, there's no supervision going on. And I just want to say another thing on this, that what's happened that a lot of you are not aware of, what's happening to our nurses out in the field, and that's my reason for being here today. One nurse called me in a frantic fit that she just got a letter from the nursing board, and this was the comment, that they wanted to talk to her to investigate her because she's alleged to be engaged in gross negligence and unprofessional conduct by operating a med spa without having a medical doctor available. So I was asked to come and meet with this investigator and the nurse, who was, by the way, finishing up her FNP training. She's been doing this for 10 years, and yet she's lost sleep for several weeks because she was accused of gross negligence for operating a med spa without having a medical doctor available. Turns out that her doctor has been trained adequately, is very, very competent, has worked with her for 6 years. They jointly, doctor and nurse, 49, 51%, own this practice together, and he's been intimately involved. And she had to go to the expense of producing documents and going to an interview and going through a half a day of interview on this thing with the fear that she was being intimidated about gross negligence. I think it was a real sad case. And just one other case that just has shocked me a great deal. I got faxed a copy of this, and it's my certainly favorite case. When she received an accusation about her practice that she's been in for several years, that the doctor lives a few minutes from the office, the nurse lives a few minutes from the office, the MD is totally available, has been involved in the practice for years, and this case was generated by a complaint from a very disturbed patient, I mean mentally disturbed patient, 5 years previous to this citation. The patient complained that the nurse's laser treatment caused blistering and eventual scarring. The case was reviewed by the BRN and was determined that, number one, the treatment was performed without an exam by an MD prior to commencing the procedure. Number two, the MD was not notified of the adverse reaction of this treatment. And number three, the RN failed to provide protective eyewear during the laser treatment performed. People, none of these have a causal relationship to the injury supposedly sustained by these patients, by this patient. Now, assumedly, if these facts were accurately verified and true, you would suppose that that RN would have to have some reprimand, would have to have some increased training in lasers and general practice, but certainly a warning about this prior exam, which we're now emphasizing, but this is a case 5 years ago. Shockingly, the RN has been deemed to be grossly negligent and incompetent for these actions. She now faces severe penalties for these allegations. They've now taken the form of an accusation. She now has to defend her position. She's a professional, and she is in serious trouble. I'm asking this committee, and the members of this committee, what is going on the enforcement side right now
They're taking bits of information and attacking nurses, sometimes turning it over to the city officials, the police department coming in with bulletproof vests.
Madam Chairman, if I could be heard on this issue.
Yes, that's under the board.
If I'm not mistaken, the accusation against the nurse is filed by the nursing board.
Yes, and may I comment that her doctor was interviewed before this regarding his role in this supposed
I'm
case.
just trying to point out to the members, in fact, that it's not this body
that is
or the medical board that have jurisdiction over a nurse.
Mr. Davis, can I ask you to kind of wrap it up? We've got one more
Give
speaker.
me 30 more seconds and it's wrapped up. Thank you, Mr. Hepler. I again plead with this committee to conclude and end the charge that you've been given over 5 years ago on the Figueroa bill. The comments that were made today, if you synthesize those and hand them back to Mr. Hepler, I think you have the meat here for concluding and wrapping this thing up. Why am I concerned? Because enforcement in the Med Board and now the BRN are intimidating and they're putting people's profession at risk because there's no definition that's tangible. Their enforcement are taking little bits of information and going out, both from the BRN and the Med Board, and causing havoc in the field. And I say, please do whatever you can as individuals on your board position with either board, and please help those in the field that are trying to do a good job, and we'll follow whatever standards you come up with.
Thank you, Mr. Davis. John Valencia, American Society for Dermatological Surgery.
Good afternoon, Madam Chair. John Valencia, representing ASDSA. I'm a partner in the Sacramento law firm of Wilkie Fleury et al., where for the better part of 90 years we've defended physicians and other healthcare professionals against in medical malpractice, licensing, and business transactions. So I think I can say with a fair amount of authority, if there's a physician foible or a healthcare professional foible known, we've seen it. We've probably defended it. As much as the American Society for Dermatologic Surgery is steadfastly in favor of a standard in elective cosmetic medical procedures that speaks to a physician on-site and immediately available, it's my personal opinion that no amount of physician supervision is going to cure some of the issues that you've been exploring over the last several hearings. I think the gem of the proposal that's been offered up today is that you punt and go back to square one, because frankly I think very little will be lost by that. Because no amount of supervision in truth is going to legitimize an illegitimate practice. That's fundamentally the case. And in our experience, both as defense counsel and on behalf of physicians in dermatology, the problems that we see, the problems that Dr. Kilmer, that Dr. Robbins, that Dr. Bruner and others treat are by and large not problems created in legitimate settings, but in illegitimate settings. My concern with the proposal, for example, that's on the table is that it will be exploited, quite possibly by several people that have appeared before you. I have my own favorite case, and it's the people of California versus Garrison, now completed. That's a story for another day. First and foremost, and Dr. Robbins, thank you for mentioning AB 1548. That's a matter of statute. And Madam Chair, with your indulgence, a couple of extra minutes. As a matter of law now, signed by Governor Brown, Chapter 140, Statutes of 2012, which was formerly AB 1548, a business organization that offers to provide or provides outpatient elective cosmetic medical procedures or treatments that's owned or operated in violation of Section 2400, that's the corporate bar, that's what you've heard referenced. It is illegal today for any person, not layperson, any person, regardless of their profession, other than physician, to own a professional medical corporation at 51% or greater. The other shareholders, the other stakeholders are also specified by law. Other than that, it's illegal to offer medical care in those kinds of settings that are not properly organized. And what will happen now, as a function of this bill, is that when a party like that contracts with or otherwise employs a physician and surgeon to facilitate its offers to provide or the provision of outpatient elective cosmetic medical procedures or treatments that may only be provided by the holder of a physician and surgeon certificate is guilty of violating Penal Code Section 550. that's a felony. And if you charge in a med spa or some other setting that's been gussied up to look like a legitimate setting, if you charge $951 or more for service, it's $50,000 and up to 3 years in prison. Because that's the kind of fraud that's going on in this field, driven by the dollar incentives that you heard about. $950 or below, also a felony, but $25,000 and lesser time potential. We've heard from district attorneys over and over and the medical board from time to time that what's needed is better enforcement of existing law. And with the medical board's support for this measure, many of you voted in support of this measure through the Ledge Committee and at the full board, it's now a function of law. It was our objective to give the medical board and other consumer protection agencies more tools to better enforce existing law. My concern with trying to bootstrap supervision, which, again, can only apply in legitimate settings, in legitimate medical practices, is that somehow that will be exploited to induce unlearned docs. I've always promised physicians and surgeons I would never practice medicine if they agreed never to practice law. And unfortunately, we get the calls way too late in the proceedings. It is already a matter of law in a legitimate setting, and if you were to extrapolate in these illegitimate settings, that no one can walk into a med spa in a strip mall and subject themselves to treatment that day. You know that's against the law. Because the Donda West bill that was signed into law last session by then Governor Schwarzenegger says, notwithstanding any other provision of law, any elective cosmetic surgery procedure may not be performed on a patient unless the patient has received within 30 days prior to the elective cosmetic surgery procedure and confirmed as up to date on the day of the procedure an appropriate physical exam by and written clearance for the procedure from any of the following apex healthcare professionals: physicians and surgeons, certified nurse practitioner, licensed physician assistant at direction. I guarantee you, you go to the suspect and illegal settings, that hasn't been attended to. So I would caution you against, in closing, I would caution you against trying to fix the multiple problems that you have accurately identified throughout the course of today's hearing. I'll close with this observation. In your May hearing, you had Deputy Attorney General Lee talk to you about this circumstance. What was ironic was that his testimony was followed by an Orange County physician. May or may not be the same Orange County physician that was referenced earlier, but he talked about his experience in cosmetic procedures. Bet he didn't tell you that he's also the medical director for a facility in the South Bay. And we examined those kinds of circumstances. There's no ownership structure there. So supervision will not cure an illegitimate circumstance. It will focus attention
Valencia,
internally.
Wrap it up.
Thank you. Thank you, Madam
Appreciate it.
Chair, and appreciate the opportunity to appear today.
If we can, see no more public comment, if we could bring it back here, and would entertain a motion of any recommendation to the full board.
Dr. Finney, could you share with us the language that you have there, and we can make a motion on that perhaps?
Okay, the one day I didn't bring my laptop, you know? Boy. Okay, it would start with not physically present but immediately available. Quote, whenever an elective cosmetic procedure involving the use of a laser or intense pulse light device is performed by a licensed healthcare provider acting within the scope of his or her license, a physician with relevant training and expertise shall be immediately available to the provider. For the purposes of this section, immediately available means contactable by electronic or telephonic means without delay, interruptible, and able to furnish appropriate assistance and direction throughout the performance of the procedure and inform the patient of provisions for post-procedure care. The one piece that I'm not quite sure how...
And such shall be communicated or contained in standardized procedures.
Okay, and that would be a comma, and such shall be contained in standardized procedures and protocols. Maybe need a grammatical tweak there, but that's the gist of it.
And that the patient knows who to contact. Is that okay?
I'd like to make a motion that we accept that language as a committee and carry forward with it.
Second.
Discussion. Yes, Dr. Robbins.
I think that
Microphone, so we can hear you.
I think that the rush to judgment is doing a disservice to the procedures, to the profession, and to the responsibility that we have assumed as members of the panel to provide medical supervision to the allied healthcare providers by adopting this motion.
Dr. Bishop?
We really aren't rushing to judgment. We're simply presenting this to the full board where further modification can be achieved. I think we've done what we can do today. I think any further crafting, we're at the limit of what we can do.
And did you raise your hand so I can acknowledge you? Doctor, are you done? Okay, Dr. Kilmer.
And can we suggest that we do look into a way to do some sort of certification or licensing or like some way to decide who's appropriate? Can we say we've addressed this issue, but we do feel that there's a need for certification, licensing, whatever
Mr. Kepler, and if I could kind of intervene for a minute, if we could go forth on this, meeting our obligation that we've been directed by the legislature to do, and then bifurcate and then additionally communicate with the legislature that we do not feel, well, we've met the requirement they have asked of us. We feel that more needs to be done legislatively to adequately protect the consumer of these services, and then give instance, for instance, legislation needs to be crafted addressing the level of training and any of the other items that that we feel was necessary.
I think you could actually wrap it up on motion. You could say, in fact, this is our regulatory proposal, but going forward, this committee believes that further work is needed to be done legislatively to at least contemplate changes in these other areas.
I think we need to be specific about why we feel it doesn't totally meet the bill, so that we communicate, as Dr. Robbins and others have said, that the legislature needs to go farther on this, but that we've met our requirement statutorily by going forth on the issue of supervision, but we need further legislation. So can I entertain a?
Well, so if you want to go that far, then I would suggest you want to amend. If you would suggest that as an amendment to the.
I'll take that as a friendly amendment.
Okay. How about the second?
Yes, I did.
Can I just ask that you change standardized procedures and protocols to or protocols? Because PAs don't use standardized procedures commonly. And then I just questioned the word that you inserted, furnish appropriate assistance. Is that going to be questioned about what appropriate? And is it necessary?
Can we make a definition in our definition?
At this point, I think it would be best. Maybe one of the things we could do is run with appropriate, and perhaps clearer minds would prevail tomorrow and see if there's a better word that comes to mind. But I think for the purpose, candidly, of getting it to the full board, the committee may want to consider going with appropriate.
Any other commentary? All right, I'd like to call for a vote on the motion as read and with a friendly amendment on that. All those in favor?
Aye.
Any opposed? Okay, Doctor.
And then just members, just so I said, the motion is going to be recommendation to the
full board, and obviously
right,
the full board.
This committee is not authorized to make regulatory decisions all by itself.
And if staff can prepare a summary so that we can obviously tell the full board the meat of the discussion and the concern that several have expressed that that while the legislature was well intended, that it missed the mark, and that we'll go forth, but we would like them to consider some additional legislation. All right.
I'd like to propose a motion to adjourn.
I would very much like to entertain that. Yes, yes.
Not to be
Voting
the most,
again.
not to be the most unpopular guy in the room, but I think we have one more thing about future agenda items, do we not?
Well, the future, if we can call for future agenda items, again, and obviously I hope we continue to meet, I do believe that we should iterate that we would like a presentation on medical spas and possible definitions. Also about the fictitious name permit, because I do think under the new legislation that we may have some real room in there, to tighten this up. And then I understand that we don't agree with the case, but if we could have a presentation on the outcome of the case on the supervision of certified nurse anesthetist, that would help. Okay. Any other items that you would like discussed?
I'll just ask a quick question. I'm always digging around for these words. The word appropriate is in the code very often, do you know?
The word appropriate kind of, like I said, it's not really an absolute stumbling block. It just goes to a question of clarity, because appropriate is a very good word in my mind for statute. It's perhaps not the best choice of words for a regulation, but we can cross that bridge.
Well, perhaps between now and tomorrow, you can help wordsmith that so that when we present it to the board, we'll be more comfortable. Yes, Dr. Robbins.
As it's presented right now, I had to not give my vote in favor of it, but I do have a question, and that is, do you have to include in this motion who is going to determine what is acceptable or appropriate?
I will defer to Mr. Kepler, but my gut feeling on that would be it would be the community standard that would be applied.
So we're getting back to that area where we have one expert saying this is the standard of care and another saying this is not, and I thought we dismissed that concept at the very beginning of our discussion.
I think that was discussed, but I do think that might be the legal standard by which...
Is this meeting adjourned?
Pardon? The meeting was adjourned.
This is off the record. Okay.
Okay. All right. And I'd like to thank everybody for being here and for your input and testimony. I think it was a very productive meeting, and good night. Yeah, why don't you give that to